What we're going to do today is that we are going to start into our more substantive materials that just have to do with this class, Political Science 302, Protecting Civil Liberties. In this lecture, one of the things that I want to kind of set out to start with is that about the first third of our class, roughly, is going to deal with the part of the First Amendment that we know as the religion clauses. And there are two of them. The smaller amount is on the Free Exercise Clause, and the larger amount is on the Establishment Clause. So there's about a third of it for free exercise, a third of it establishment. And then after we finish this, we move on to other parts of the First Amendment dealing with freedom of speech, which is probably our largest topic, even more than the religion parts, and then moving into some things like freedom of the press, freedom limits on the First Amendment, and the internet, bringing up some things there, as well as freedom of association. So I usually put this at the beginning of each chapter just to let you know which cases that we're going to go over during a chapter. And these are the ones that are in your book. There are ones that you will see that I'm going to talk about that are listed in your syllabus as supplemental materials. So I don't have you read the full cases. I usually just have you read a summary of them. And those are cases that have been more recently decided by the court that haven't quite made it into your textbook. So today what we're going to do, of course, as you can see here, we're up to lecture 4. Even though, if you remember, some of the 3s were kind of spread out amongst each other, just to kind of group them a little bit better. And we're going to look at the definition of a religion, kind of an overview of some things about religion in America, as well as the valid secular policy test, and then we'll get into the Sherbert-Yoder test. The Sherbert-Yoder test. It's Sherbert versus Werner. So our plan today is kind of to go this way, is kind of my plan for y'all, is the parts kind of at the very beginning of the kind of unit about civil liberties. Just kind of skim that on your own. So to start with, we'll kind of cover the first 10, 11 pages or so, talking about defining religion and the valid secular policy test. Then we'll move into the Warren and Burger courts on how they interpreted the Free Exercise Clause as well. And we'll have 2 major cases, Sherbert versus Werner and Wisconsin versus Yoder. Now, one of the things that I hope you're going to kind of notice as you go through the materials is that we have the main cases, and then we have what I kind of call note cases. So if this was actually a law school textbook, there would actually be, instead of, as you see, they just have some discussion, there would literally be some little notes after that discuss some of the different cases. That's where I get the term note cases. So they are cases that you don't read an excerpt of the opinion so much as you kind of get more of a summary of it. Now, those cases are important, and the more important they are, the more I'll talk about them. So, the question is, could you get a question on your exam about some of the note cases? The answer is yes. So, if I mention one in passing for 5 seconds, probably not. If I talk about one for several minutes, probably yes, potentially. So just to remind you, this is that your first major exam will be on chapter 4. So just chapter 4. And that will be after we finish these materials up. So I think we have to kind of start out with thinking about just the issue of religion in early America. And when I'm talking about early America, I'm talking about basically British North America. Which was the basis of what the modern United States is based on. Even though there's a lot of territory that was owned by other people before anybody else got here, and then was taken over in other parts of what we know as the United States, by other countries, before it eventually became where we are at today. So religion in early America did vary by colony. So the colonies in New England, with the exception of Rhode Island, um, were largely settled by what we know as the Puritans. So if you're ever wondering what the religion today of the Puritans is, it's called the Congregationalist Church in the United States. Um, one of the things, not to burst some people's bubbles from maybe some high school teachers that maybe didn't know a whole lot about history, whenever you hear people say, oh, they came here for religious freedom, I'm kind of like, that's not quite the whole story. So they were called Puritans because they wanted to purify the Church of England. So they wanted to purify it, for one thing, of kind of some of the vestiges of the Anglican Church kept with Catholicism. So a lot of the rituals and things in the Anglican Church resemble some things in Catholicism. The Puritans didn't like that. They didn't get their way, so they decided to come over here. Now, okay, we say, they're coming here for religious freedom. Well, did they want to give religious freedom to the people that were going to be in the area? Not really. So, in some ways, the Puritans kind of established more of a theocracy in some of these places. So if you don't believe me, look up Salem witch trials. Yeah. But eventually the folks that are in this area become much more religiously more tolerant of other faiths, let's say. Now, some of the other colonies were founded more as economic units. So if you think of the Jamestown settlement and some of the others that come into the country, those were founded more as economic units primarily. Then you started having more and more people come over. But when you're talking about the Puritans, that was started as a kind of a haven for these folks that wanted to purify the Church of England. So they bring that over here. But if you're talking about, say, Virginia or Georgia or South Carolina or the Carolinas, or New York, which was once New Amsterdam, owned by the Dutch. Most of Delaware was once owned by Sweden. And then, you start moving into other parts of the country. What you would see outside of, say, in British North America, the French and the Spanish, they came with the idea, especially the Spanish, with proselytizing the native populations. Now, did a lot of the native populations not make it? No, they didn't. But one of the differences is with the British is that you just initially just started seeing a lot of people from Britain and other countries start coming over here and settling it. And the problem was it was already settled. So you're moving some people off of their lands. Now, you have some, with these, the settlers were not here in places like Virginia initially for some type of religious purpose. Say like they were in New England. Or let's say, if we were talking about the southwest of the United States, as we know now, the Spanish. So a lot of them just brought the religions that they had over to the United States. So hence, a lot of early religion in the United States were the Congregationalists up in the Northeast, and a lot of Anglicans, but also a lot of Presbyterians. When you started having more Germans coming over, started getting some Lutherans. You're Catholic. Same thing with the Swedes in Lutheranism. And French and Spanish Catholicism. So they were bringing over, and a lot of the Dutch who were bringing over the Reformed Church. You also had the Quakers coming over. So Maryland was initially set up as a haven for Catholics. So what you have to remember is that when you go back a little bit in history, the Henry VIII, he can't get a divorce, so he's like, Pope won't give me a divorce. I'll start my own religion, and I'll be the head of it. And, Elizabeth II is still head of the Anglican Church today, technically. Well, after she dies, after Henry VIII dies, he didn't have the son that he wanted that was going to, hence one of the reasons for, getting rid of so many wives. the first daughter was an offspring of his marriage to a Catholic princess. Well, she started bringing back Catholicism. Well, that didn't go over in some ways, but the problem is she didn't live that long. If she would have lived a lot longer, maybe that might have worked, but she didn't. Then we had Elizabeth, who reigned for a long time. And what you saw in that period after, especially whenever you had some movements to try to restore Catholicism, and eventually you had, the planning of Ulster, bringing over Protestants into Ireland to try to do some things there, which, we still live with some of the issues there. But after, let's say, not just after Elizabeth, let's say after the Battle of the Boyne in 1690, what you started seeing in Britain, it had been going on during the 17th century, but in the 18th century, a lot of laws that were being passed that were very, very anti-Catholic. So remember, just because the king says change religions, that doesn't mean everybody just wants to automatically change religions. Like, oh, the king says I'm an Anglican. Well, a lot of people are kind of like, no, I don't think so. But there were a lot of laws that were passed in Britain that were very anti-Catholic. And because Britain controlled Ireland, they were imposed on Ireland, which did not go along with that. So that's where you have initially a lot of the anti-Catholic sentiment that kind of starts in the United States. Now, it's not as virulent as it ever was in England, because you don't have the legacy in the United States of Reformation. Now, Rhode Island was a colony that was founded by Roger Williams, and it was founded on the belief of religious tolerance. Roger Williams known as one of the greatest Rhode Islanders. So a lot of the discrimination did flow against Catholics from England. Now, our founding fathers, as we know them, they were of various degrees of religiosity. And at that time, as far as a lot of them, you had some that were much more orthodoxly religious, but a lot of them were more deists. So, kind of a different take on things. So, I have this here. What are deist beliefs? The universe was good and orderly. Perfectibility of everyone through the use of reason. God's objective was happiness. The best form of worship is to do good to others. So, a lot of this was more, yes, there's a God, but it's largely more hands-off. It's up to us to do some good things here. Now, technically, were they all professing Christians of some degree or another? Yes. But there's always some question about that. Some were much more overtly religious than others. Now, most of the people that ended up were our founding fathers, signed the Declaration of Independence or signed the Constitution. The largest three of them were Congregationalists, Presbyterians, and Anglicans. As you can see there, the Congregationalists, the Puritans, and the Presbyterians and Anglicans were the folks that came over from England and Wales and Scotland and Northern Ireland. There were a few others that were Lutheran. There were some Quakers. Of course, Ben Franklin was a Quaker. The Dutch Reformed. Remember, there was a decent-sized Dutch population. If you ever go into the Hudson Valley of New York, you will see a lot of things have rather Dutch names. So if you see things that end in kill. Even a few Catholics. So what you see there also is something you don't see as much today. That is a major force within Protestantism in the United States today. You don't really see the evangelical, fundamentalist, or charismatic denominations. So a good way of saying this is that what we know today is more mainline Protestants were the founders, and not the evangelicals or fundamentalists so much, or the non-denominationalists. But a little historical primer to kind of talk about kind of where we're going there is that America today is one of the most religious countries in the Western world. Now, it's less than before. What we have today is the so-called rise of the nuns. And I'm Catholic. Immediately when I say the rise of the nuns, I start thinking, are the sisters making a comeback here? Well, I'm not saying nun is the sisters of the Catholic Church, I'm saying none as in None. So basically people that are very secular. So not necessarily people that are saying they're an atheist, but more agnostic. Agnosticism has really taken a trend among the young. We'll see if this continues, but one of the things that that's going to mean is that if younger people continue to be more secular and agnostic, it's going to carry over as they get older, unless they start gaining more religiosity as they get older. But the other thing that you have to remember when you have a religious country that's a democracy, these religious people are going to be voting for things, so it is going to influence policy at some point. Now, at the founding of the country, many states had established religions. Few actually kept established religions into the 1840s. Many had religious tests for office. But as far as in our Constitution, religion is only mentioned twice, as we're going to see. Article 6 of the Constitution, no religious tests for federal office. Now, some states continue to have their own religious restrictions, and some of them are actually technically still in a lot of state laws and constitutions. But, they're not enforced. It would be very difficult to enforce them. The simple part here in Article 6 is, but no religious test shall ever be required as a qualification to any office or public trust under the United States. Now, that's saying under the United States. If a state literally tried to do that, I think you would have a lawsuit, but, you kind of have to see how that would go. Would they incorporate part of Article 6 against state and local governments? And then the First Amendment, as we're going to see. Congress shall make no law respecting the establishment of religion or prohibiting the free exercise thereof. That is not that many words. But we have a significant amount of pages that we're going to be looking at. Now, just to remember, the United States is still majority Protestant. We've only had 2 presidents that have not been Protestant of some form or another. If you're wondering what the largest number of presidents have been Episcopalians, which is the American version of Anglicanism. We've only had 2 presidents that were not Protestant, and that was President John F. Kennedy and President Joe Biden, both Irish Catholics, members of the Roman Catholic Church. Now, that's not to say that we haven't had some presidents that were much more overtly religious, or even privately religious, versus some that may have some religious beliefs but are very secular. So, as far as modern presidents, as far as folks that are much more overtly religious, I think you would have to say that about former President Carter, devoutly Southern Baptist, George W. Bush had a lot of support of evangelicals. He was a United Methodist, and of course, current President Joe Biden, very, very much into his Catholic faith. While some others were maybe more in between. Some, just didn't do a whole lot with it. Not big church attenders. Say like former President Trump had a lot of support for evangelicals, but spent most of his Sundays playing golf, not going to church. President Reagan rarely went to church, and he had a lot of support from evangelicals. It just kind of depends. Though I would just say this, is that Lyndon Johnson sometimes did attend Catholic services because one of his daughters had converted to Catholicism when she got married. So that's kind of your little bit of an asterisk there. So you have had some influence there, but even as far as nominees, we've had several Catholic vice presidential nominees. Only one Catholic vice president being Joe Biden, but we've only had one person of another outside of the Christian faith been on a ticket as a vice president. It was Joe Lieberman in 2000, who's an Orthodox Jew. Now, the other thing that we've seen is that there is a lot of religious diversity in the United States, especially as it expanded in size, and especially with immigration from other places. So, whenever large chunks of people come and migrate to another country, they're going to bring their religion. They're going to bring their culture. For a while, they're going to bring their language, Some still keep their languages. Though what we've seen in the United States, especially after World War One and some other things that we'll get into a little bit later, really a movement in World War One and after to suppress a lot of non-English languages in the United States. Now, we always had this strain of anti-Catholicism. Well, when there weren't that many Catholics, people weren't as people that were held those views weren't exactly that disturbed. But then you start getting these large surges of immigration into the United States from largely Catholic countries. And when the United States picks up new territory, of course, when you have territory that was Spanish at one time and French at one time, there's already going to be a lot of Catholics there. But when you start seeing a flood of Catholics from Ireland, Germany, and then especially Italy, Poland, Hungary, being the largest sources of Catholics, and also French and French Canadian, that's a whole different story. And then later we see, with some of the immigration reforms, a surge of Latino Catholics into the United States. Also, there have been Jews in the United States since before the Constitution was written. And one of the positive things about the United States is that, with a few exceptions, say the Leo Frank incident and a few others, we have never in the United States had the extreme amount of anti-Semitism that plagued Europe. So there were no pogroms in the United States. Now, we recently did have the massacre at the Tree of Life Synagogue in Pittsburgh. But Jews found the United States to be welcoming. Was there discrimination? Yes. Is there still? Yes, of course. Now, most of the Jewish immigration into the United States came from Eastern Europe. So a lot of it from what we kind of know at the time as the old Russian Empire. So these Jews are known as Ashkenazi Jews, to be separated, say, from Sephardic Jews, but more largely from Eastern Europe. Now, the immigration that was coming in addition with World War I and the rise of the Ku Klux Klan, led to the most severe immigration restrictions ever in the United States, beginning in 1921 and then carried forward into 1924 with the Immigration Code Act, which basically cut immigration by about 90% in the United States and limited about 85% of it from Germany, Ireland, and Great Britain, which includes Scotland and Wales and Northern Ireland. Now, when the quotas were abandoned in 1965, so this was the Immigration Nationalities Act of 1965, I sometimes say it's one of the four major pieces of civil rights legislation because, we basically had a race-based immigration policy in the United States until 1965. It opened up immigration to the entire world, and we began to see much more diversity outside of traditional Christianity. So you started seeing people that were the Buddhist faith, the Hindu faith, Muslim faith, just to name a few. Now, another thing that we have to keep in mind is that, we are a relatively young country. A lot of countries in Europe are really old. We've basically been a country on this planet since 1776. So one of the things that this has meant is that in addition to the Native American religious traditions, we have had a number of religions that were actually started in the United States that are uniquely American. Now, have they spread around the world? Of course. But the Church of Jesus Christ of Latter-day Saints, that was, where was it started? It was Vermont and then to New York, and then it moves over into Utah eventually. Don't have time to go into the history of the LDS faith. The Shakers, the Seventh-day Adventists, the Jehovah's Witnesses, which will play a big role in free exercise cases. Christian Science, Pentecostalism, Reconstruction of Judaism, and the Nation of Islam, which is something that we'll hear a little bit about here in a second. So, just to kind of let you know, I thought I'd throw this map up there this semester. So this is a map from a group called the ARDA. They collect religious data. Just this, if you're wondering, what is the largest religious denomination by county in the United States? So what you can kind of see here is that the kind of light blue are counties where the largest denomination is Roman Catholic. Or actually, I should just say Catholic because it would include Eastern Rite Catholics in this as well. And what you can see there is that pretty much, not quite all, but most of the Northeast, the largest denomination is Catholic. In the Midwest, it kind of moves around, and then when you get kind of into South Florida and in the Southwest, you see that. Now you're wondering what those little dots are, because you see a dot on Erie County, and if you were to look a little closer, you would see a couple dots up there in the north, or 3 dots there in the North Country, and I think you see one in the Hudson Valley. Those are counties where that one religious denomination constitutes the majority of the population. So, according to the ARDA, American Association of Religious Data Archives, about 60% of the population in Erie County identifies as Catholic. So, we are in one of the more not as religiously diverse counties. Now, that still means that 40% are of other religions, but you can see on there that there aren't that many places where there are dots. Now, when you start moving kind of into some places in the upper Midwest, you kind of see the peach goldish color there. You see some dots there for the Lutheran faith because you had a lot of Germans and Scandinavians move into those areas. And then when you get in the South, you're talking about the Baptist faith, and you see some dots. You see quite a few dots in some places there. And you look out west, of course, if you're wondering what that kind of, I don't know what color say that is, kind of a. All right, look at Utah. Is a good way of putting that. You see a lot of dots there, so very heavily concentrated Mormon populations in those areas. But you also see there southern Louisiana, very, very non-diverse Catholic populations. So very heavily Catholic populations there in South Texas. So as far the Catholic Church is divided up into dioceses and archdioceses. The 6 most Catholic dioceses and archdioceses in America are in southern Louisiana and South Texas. And you see some other colors there. You see some kind of non-denominational Christians in some places in the Midwest and here and there. Some counties in southern Ohio and other places where you see the Methodist faith. But you kind of see that the country is more religiously diverse. You see a few counties there in Michigan and in Iowa where the Dutch Reformed Church is the largest religion, and a few places you may notice if you see some pink, Mennonite and Amish. Yeah, there's some places where they're the largest group. Even a few places, if you look in Alaska, where the largest group are Orthodox Christians. Still a lot of the legacy of those areas once being part of Russia. So, if you're interested in this, pause it, take a look at it. I always find these maps fascinating, to see, who lives where. So you can see that Baptists are the largest group in most of the South, and really, you don't see too many red dots other places. Now, if you're to kind of look out west a little bit, kind of there in Oregon and Washington, you see some places that are marked as other. Some of those are actually areas that none is the largest, and I think think those are the only areas where you really see that. Now, how do we define religion? So, we've talked about religion in America, which I think is kind of a good way of getting into it for those of you that aren't kind of familiar with a lot of American religious tradition. You can have a whole class on it. So how do we define what religion is? Some of them are very large. So the largest single religion in the world is the Roman Catholic faith. About 1.4 billion people in the United States. Not in the United States. There aren't that many people in the United States. In the world are Catholics. Now, they might not be a Roman Catholic, but their allegiance is to that guy there, Pope Francis, or whoever the Pope is. Is the leader. You got St. Peter's there. One of the largest landholders in the world as well, Catholic Church. I am a member of it. I don't think anybody would say that the Roman Catholic Church is not a religion, or that conservative Judaism, or Sunni Islam or Shiite Islam, which of course that branches of Islam are divided up as well. They're not just here and there. But again, not enough time to get into that. But what about new religions? Of course, as I just told you, we've had religions that were just created not that long ago in the United States. Protestantism didn't exist until the Reformation, about 500 years ago. Orthodox Christianity didn't really exist until about 1,000 years ago. Or a little over 1,000 years ago. Spouse is Orthodox. Which, the thing is, we get to celebrate Christmas twice. Which, hold on to that, because I wish we could have always had this in class, because I'll save that for when we get into Establishment Clause. I don't want to jump the gun too much. So when you're talking about a new religion, how large? They were all new at one time. So Christianity was once very small. Now it's well over 2 billion people are Christian of some form or another. But can people just get together and call themselves a religion? Because one of the things in the United States is, our tax code, you have the non-for-profit there, and if you're a religion, you qualify. And then, of course, the thing that we're going to be getting into in this chapter, what accommodations does the government have to provide for religious beliefs? So, one thing the government loses a lot of money on is that church properties are tax exempt. Now, if, let's say, a church runs some type of charitable organization, and let's remember, one of the largest health providers in Western New York is Catholic Health. How do you treat them? What do we do say about Catholic charities? Which is the case that we're going to get into at the end of the next lecture. What can they do if they accept some federal money? Because sometimes some of these religious organizations, they may have a religious purpose, that they may be really good at providing aid. And then, let's say, when can religiously based laws be placed on other people? Which is something we're going to get into with a few of our cases there. Now, in Davis versus Beeson, way back in the day, one of the things that the court in that case said is that they said, well, it comes down to some belief in a God. I didn't say which God or gods, but in relation to a creator and the obligations that imposes. Now, then we start getting to the Ballard approach, which the Ballards, if this sounds familiar, maybe it should. They were the leaders of what they called the I Am movement. They claimed they had supernatural powers to heal, wealth, and success. All you had to do was send them money. I kind of put them in with modern-day televangelists. So Joel Osteen, the guy that has the mega church down in Houston, that's his house. He sure didn't take a vow of poverty. Seems like he took a vow of luxury. Which master is he serving? Might be a good question. Not a big fan of Joel Osteen. But, we'll see something here from John Oliver in a second. I don't have time to put the full one in here, but I have a little bit of it. So the government said this was basically some kind of fraud scheme, that you're just trying to get money. Now, one of the things, of course, is that, if people want to hand over their money to somebody that's not exactly the most honest person in the world, can you stop them? I mean, that's kind of where I kind of come down on that. But should you give them tax exempt status? Now, Justice Douglas wrote for the court here, and basically said we're going to consider the sincerity of the beliefs, not the truth. So, the religious views espoused by the Ballards might seem to be incredible, if not preposterous, to most people. But if those doctrines are subject to trial before a jury charged with finding the truth or falsity, then the same could be done with the religious beliefs of any sect. Then the triers of fact undertake that task in a forbidden domain. So, I mean, that's the thing, is that, one thing that some people that are religious and some religions basically say is that you're kind of with us or against us. So, there are some countries in the world where there is not religious freedom. That, if you try to practice a religion that is different than the state religion or listed religions, you can be punished. So who's to say what religion gets counted and which one doesn't? Now, another thing that you get into is the issue of conscientious objectors. So Congress passes some protections for some religious groups in 1940 as we're getting into World War II and the draft. Now, if you don't have a draft, it's not as big of an issue because, relying on volunteers. But when you're forcing people in, they have to be formally opposed to participation in any form of war. Now, those would generally be given. Sometimes they would be given jobs in place of the military service. There were some instances where you would see somebody that's a conscientious objector maybe get a job in the military, but in a non-combat role. Maybe sometimes folks were corpsmen or something like that. Now, as far as the Jehovah's Witnesses, a group that we're going to see quite a bit about in this lecture, and we will come up in the next section of the course too. What the court in Ciccarella said was that theoretical participation does not preclude status if they were opposed to all real war. So this was used in a case called Clay versus the United States. You probably think, who is Clay? Better known as Muhammad Ali. So Muhammad Ali was born Cassius Clay, converted to the Nation of Islam, later converted to just Sunni Islam. But I want to show you this clip here about Muhammad Ali when he passed away. If I can get it
but a lot of us who came up in that era remember him saying Cassius Clay was my slave name and insisting on his new name, and the almost universally white news and sports media took a long time to climb on board that bandwagon and fall in with the program. And if you were a kid my age, the first time you ever heard the expression conscientious objector was when Ali said he wouldn't go to Vietnam. I just want to hear his voice for a moment on that incident particularly.
There haven't been very many Negroes in this country who have protested the draft in the sense that they have gone in and fought. Do you think that you are setting some kind of an example that perhaps some of them may even...
I'm not out to set no examples for nobody to follow. I'm a Muslim. I'm with 600 more million who believe the same as me, and I'm just sticking to my religious beliefs in the Holy Quran, which was there before, long before I was thought about coming into this world. I'm just following my religious beliefs. I'm not advising them or telling them nothing to do. I'm just following my religious beliefs to the death right now. I die right now. Whatever happens will be the will of Allah. Many parts of the world, the people are protesting, but still, I mean, I don't rely on that. I rely totally on Allah, the Lord of the worlds.
Just how far would you go to keep from taking up arms?
I'll die. It's anything that's against my religious beliefs. I'd rather face machine gun fire before deviate from the teachings of Almighty God and the religion of Islam. I would die.
Well, in this situation, you wouldn't have to die. It would mean that you'd go to jail if you really...
I'm not saying where I will go. I'm just letting you know.
well, we don't need to listen to Chris Hayes here tell us about this, but the fascinating thing about that, you might remember some of the things that I was showing you from that movie called about Muhammad Ali's case that were really fascinating. Is that initially you didn't think that the case was even going to be heard by the court. It had been rejected several times for a cert petition, but Brennan, Black, and Douglas, the three liberals that were on the court at the time, Thurgood Marshall had recused himself because he had been involved in the case of the Solicitor General and absolutely hated the Nation of Islam. So one of the things that Thurgood Marshall had long said is that Elijah Muhammad, he never called him Malcolm X, he always called him Elijah Muhammad, said that they were segregationists and I'm an integrationist. Which the thing is, there is a lot of merit to that statement. But he was recused on it. So you need 4 votes to grant cert, and they got Potter Stewart. But the problem is, 4-4, a 4-4 tie means that decision of the lower court stands. But it was actually a 5-3 vote because Black did not vote with them, with those justices in the conference vote, and it was assigned to John Harlan. And one of John Harlan's clerks got him to read the book by Elijah Muhammad, Message of the Black Man. And he found a way to get the court to reverse the conviction without having a precedent. That's why it was unanimous. So you couldn't have got some of those people to have signed. You couldn't have got some of those people to sign on to it if not that. And Berger just kind of came along at the end and was just kind of very bitter about it, because he was kind of a bitter man on the court. Well, why did Muhammad Ali keep coming up again? So does somebody have to be a member of an actual religion? An organized religion. So, you always have some people you talk to, they're saying, are you religious? They're like, well, I'm kind of spiritual. I don't really go to a church, but, I believe in these certain things. Well, United States versus Seeger, what you had seen is that Justice Clark said reference to a supreme being was meant to exclude those from claiming status based on political, sociological, and philosophical views. One did not have to believe in God to claim an actual exemption. So you're only looking at the sincerity of the belief. And then you have a plurality opinion in Welsh versus the United States, where Justice Black said, you can claim status based on moral or ethical views if they were sincerely held. Kind of an interesting way of putting it there. So basically, non-religious views can take on a religious character. Now, what you see after that, though, is while the court really doesn't have a whole lot of cases after that, because a lot of these were having to deal with Vietnam, and people were finding a lot of ways to get out of Vietnam. So, Muhammad Ali literally said, I am not being drafted. I'm not going to be inducted. And he was stripped of his title and was banned from boxing during the prime of his career. And as he said, I was willing to die. And, if the Supreme Court wasn't going to overturn his case, he said, fine, I'll go to jail. He said, I'm not going there. One of his statements is that no Viet Cong had ever called me something that starts with an N. One of his famous statements. And whether you agree with him or not, as far as what he did, you do have to admire the fact that he had a certain position and he was willing to take the consequences for it. Of course, there were other people that were finding other ways to get out of Vietnam. You see these folks here saying, I have a certain objection to it. You had some people had bone spurs based on kind of a interesting diagnosis. We'll just leave it there. Now, I want to show you this here. I just had to show this. When John Oliver tried to mock televangelists and is talking about his Church of the Perpetual Exemption. So that's a funny little thing. I thought it would be a good segue to talk more about the free exercise clause. So basically, the language says Congress shall make no law prohibiting the free exercise thereof. I'm talking about religion. Now, one of the things that we're going to see kind of throughout this chapter, sometimes they work against each other. So when somebody's exercising their free religion, is that sometimes working against the Establishment Clause? Now, Jefferson said it was not limited. So where we kind of see here is that the court kind of comes up with a little bit of a dichotomy, that no limits on beliefs, but there are limits on actions. Because some of the actions, it turns out, of some religions, these are going to be smaller religions that are not kind of the mainstream, are not going to be popular with the country as a whole. And kind of the initial case that the court takes up on this was polygamy. So the Mormon faith, the Church of Jesus Christ of Latter-day Saints, until I believe 1890, polygamy was part of the religion. Now, there are some people that are known as FLDS, fundamentalists Mormons, that the official Church of Jesus Christ of Latter-day Saints say if you do polygamy, you're out. You are excommunicated. You can't be with us. So Mormons today, no polygamy. If somebody tries to tell you that mainstream Mormons practice polygamy, they are lying. They do not. What you have are these breakaway sects that sometimes still do. Now, Chief Justice White said, Congress was left free to reach actions which were in violation of the social duties or subversive of the good order. So he said that it's fine to believe in polygamy. The problem is when you just try to practice it. So again, monogamous relationships, okay, but when we have this strange new religion that is being introduced into the United States, and they want to do something, you can't do it. So, there are other practices of some smaller religious groups that sometimes aren't that popular, and we're going to see that comes up with the Jehovah's Witnesses. We'll see this with the Amish. There are some religions that practice Santeria, ritual slaughtering of animals. Some people don't like that. They're perfectly willing to go to the grocery store and get something from the chicken plant that the chicken went through a hell of a life. Versus getting its throat cut. By somebody. What do you think they're doing at the Tyson plant? They actually have a throat slicing machine. That was actually when I was in elementary school. We got a tour of the chicken plant locally. I always thought it was to tell us that we need to get a good education so that we didn't have to work at the chicken plant. Now, as I mentioned before, one of the things that comes out of World War I was a real draw inwards in the United States. The belief that we shouldn't be looking outwards. And something that also rose was the growth of the second Ku Klux Klan in the United States. The second Ku Klux Klan was much more northern, and its largest states were Indiana and Oregon. So this was not the Klan that we think of after the Civil War, or the Klan during the civil rights period, or the one today. I mean, the one today is just kind of a small shell of itself, let's say. So there were a lot of it was mainly anti-immigrant and anti-Catholic. So they got and they controlled government. They controlled the state government in Oregon and in Indiana during the 1920s. So this was not some small movement. It had in some states majority support. There were many counties in Indiana where 30-40% of the adult male population were members of the Ku Klux Klan. So this was not some tiny movement. At its height, it had about 6 million members. That's a lot. And there were even women's auxiliary versions of the Klan. Women of the Klan. So they got the state government to make public school attendance mandatory. Now, one of the things that we're going to see when we get to the talk about the Establishment Clause is that a lot of the public schools in the United States, they kind of did sort of have a little bit of a state religion. It was Protestantism of some form or another. Used Protestant prayers, used readings from the King James Bible. So because of this, Catholics set up their own separate form of education in terms of parochial schools. One of the reasons it was able to survive was a lot of the sisters were a lot of the teachers, and they did not pay them kind of salaries that you would regular school teachers say in a public school. So they were designed to basically close the Catholic schools of the area. So the sisters, they received a lot of their support from teaching. And they actually were supported by a lot of other religious groups, because they were worried, of course, if you could go after the Catholic Church, which was a very significant chunk of the population, unpopular chunk, what about going after some smaller groups? But the thing is, not just some of the more smaller churches, but also you saw Lutherans and Episcopalians, big groups. So Justice McReynolds here, rule for the sisters, said they were engaged in what they called a useful and meritorious taking. Here, the inevitable result of the enforcing act would be the destruction of the Pelley's primary schools. Pelley's are engaged in a kind of undertaking, and not inherently harmful, but long regarded as useful and meritorious. Certainly, there is nothing present in the record to indicate that they have failed to discharge their duties to parents, students, or the state. So, it's not like you're taking people into, Jim Jones and some type of cult here. I mean, it's Catholic schools. So, you can't do it. Now we're going to start to get into talking about our buddies, the Jehovah's Witnesses here. A group that has some unpopular opinions within Christianity. Some Christians do not consider themselves Christians, consider Jehovah's Witnesses Christians. Of course, the thing is, there are a lot of people that are Christians that don't consider a lot of other Christians Christians. That's always just been a big thing within Christianity. Led to a lot of wars and things over time. So the appellants, so the thing is, you might sometimes see them at train stations and stuff. They're passing out, to pass out things through the watchtower there. They were in a largely Catholic neighborhood in New Haven, Connecticut. So they were going house to house passing out pamphlets, and some people took offense. So they are, you have to remember, religions are inherently proselytizing, because if you just think about it, if you think that your way is the way to eternal salvation, you want other people to join too. So some people are just a lot more aggressive in the proselytizing. Now, the proselytizing centuries ago was a lot more aggressive than it is now. But, people passing out literature to you, going door to door, which something kind of bothers people. Why are you coming to my house? No, don't do that. Go home. So they were arrested under a state statute requiring a license to solicit. So what you had here is they required be granted only to organizations that were religious or a charity, and one official would make this determination. So this is going to be the problem. One official is going to make the determination. It gives too much discretion. So the Jehovah's Witnesses, it turns out, as you can see on box 4.4-1 on page 100, have brought a lot of cases before the Supreme Court. So I don't have a slide on this, but I'll just kind of talk about some of the ones that we aren't going to look at during the course so much. Murdoch versus Pennsylvania, local government may not impose a tax on the privilege of religious solicitation. In Martin versus Struthers, city may not forbid knocking on doors without the resident's permission. Nicamo versus Maryland, city may not deny a permit for a public meeting because it finds the group's belief objectionable. Thomas versus the Board of Review, state may not deny unemployment compensation to an otherwise eligible person whose religious beliefs refuse to work for a weapons plant. Watchtower Bible and Tract Study versus Stratton, city cannot require a permit as a condition for engaging in door-to-door solicitation. They're very litigious, and they've actually been very successful. So the questions that come about in Cantwell: should the Free Exercise Clause be incorporated against the states? So remember the chapter that we had just talked about, where we kind of came up with the book, like I told you in that, they could have came up with lots of different cases. One of the reasons I think they did those is that those are not ones that we read about as much within the book. So should it be incorporated against the states? So we're getting to 1940. Should the Free Exercise Clause get incorporated? So I want you to kind of keep note throughout the course when each particular part of the Constitution gets incorporated against the states, because that's often a very frequent question I ask on an exam. So if yes, if it is incorporated against the states, does it violate the Free Exercise Clause? Now, I know a lot of you are probably thinking, and every time I teach this, I'm always thinking, well, whenever I have somebody ask me who the Jehovah's Witnesses are, I'm always kind of, that's a good question. So I'll show you this clip. So I hope that shed a little light on who we're talking about now and some of their beliefs, because that does a better job of explaining Jehovah's Witnesses better than I really could. Just one thing there at the end that was a little bit off, that I learned. One of the people on my dissertation committee was a Mormon, and he informed me that the prohibition on caffeine is only for hot caffeine. That he could have caffeine in his Diet Dr. Pepper. Because I kind of wondered about that. Is that caffeine free? It's like, no. Coffee's a problem, but not Diet Dr. Pepper. So in Cantwell versus Connecticut, some of the arguments here is that they said that Cantwell, so you can see his picture, the son there. I'm sorry. The son, yes, I believe, that were the subject of this. So there's a picture of them with their newsletter. They said that the statute denies their freedom to worship, thus it violated the Due Process Clause of the 14th Amendment, and it should be incorporated as a liberty. So this is when you're starting to get, before you get the big cascade of incorporation. And that door knocking is part of their religion, because they need to be able to go proselytize. If you're talking about the end times, if the times are going to end pretty soon, you need to be getting as many members as possible. So for Connecticut, they said the state has the police power here against fraud, and that's the reason behind the law. And it doesn't apply to their ideas, only their solicitation. There's no restriction on their worshiping. It's just the solicitation. And it's proper authority to delegate this to the Secretary of Public Welfare to determine whether the solicitors are legitimate. Now, of course, the thing that they're kind of saying here is that, if you're giving that person all this power, are they maybe going to grant things to popular groups and not grant to unpopular groups? So this is Justice Roberts. This is not John Roberts. And Owen Roberts is no relation, if you're wondering. Roberts is a fairly common name. He delivers the unanimous opinion of the court here. So this is a unanimous decision. And the first thing that really they get to here is the issue of whether this is incorporated. And the answer is clearly yes. So this is going to be applicable to state and local governments. And that is something that is pretty much dispensed with pretty early on. The fundamental concept of liberty embodied in that amendment embraces the liberties guaranteed by the First Amendment. So not exactly something that is that controversial. So freedom of conscience and freedom to adhere to such religious organization or form of worship as the individual may choose cannot be restricted by law. Now, then he goes to the dichotomy that we're going to see, that we've seen before. Freedom to believe, freedom to act. Belief versus actions. The second is not absolute. The first is. You can't tell people that they have to believe something. The second can be regulated. But the thing is, this is me here. It's not the central tenet of a religion to get new followers. I mean, let's say you don't like religion and, come up with your reasons why they say that. But, if you believe that, you are the way, to eternal salvation and things are going to be a heck of a lot better, you want to get new followers. But one of the problems here is that it gave too much discretion to the secretary here. Now, what he said is that Connecticut had enforced a law that included all solicitation for a non-governmental goal, such as fraud prevention. So it's kind of one of those more, all or none. Are you giving this person, such a censorship of religion as a means of determining the right to survive is a denial of liberty protected by the First Amendment and included in the liberty which is under the protection of the 14th Amendment. So the key here that Justice Roberts talks about is something that's coming back during the John Roberts Court, and that is neutrality. So I want you to keep that in mind for when we kind of get towards the end of this section on free exercise, and is really making a comeback in terms of the issue of neutrality when we're talking about the Establishment Clause. Now, however, what he says, if the goal is secular, most will survive this test. So then we kind of get where we're seeing the valid secular policy test. So in Minersville School District versus Gobitis in 1940, another Jehovah's Witness case, and this is the family there, if you were wondering. So it involved the Pledge of Allegiance. By the way, you know, if you're in school and you don't want to stand up and say the Pledge of Allegiance, you don't have to. I think sometimes some people are into the law and want to tell you that you do. You don't have to. You know, there may be a lot of social pressure to do so. But one of the things that I think a lot of people don't realize is now we kind of do when Pledge of Allegiance, you know, you put your hand over your heart and, you know, you recite this little statement there about the flag. And, you know, under God was added in the 50s. It wasn't originally in there. One of the things is that it originally ended in a flag salute. So one of the things the Jehovah's Witnesses were saying was kind of like the Nazis. You know. And one of the things that I always say is that you really don't want to compare a whole lot of people to the Nazis other than the Nazis, because, you know, not a lot of people quite that bad. You know, saluting a flag versus Hitler, a little bit different. But the problem was that they said it was mandatory with punishment for refusing to do so. So this is one of those unpopular beliefs of the Jehovah's Witnesses. You know, they're kind of like, well, hey, they're showing out worship any graven image. You know, we don't do that. You know, it's against some of the reading of the Book of Exodus. So this is something that was requiring the flag salutes was getting bigger and bigger in the 30s and towards that. So, you know, they were saying, well, it's the same as Heil Hitler. Well, it's not the same as Heil Hitler. But the 8-1 decision, Justice Frankfurter upheld the law. So they said it was, Justice Frankfurter says it was for the secular purpose of fostering patriotism. So we're not going to disturb the local decisions that come out of this. And one of the things that this did do is it led to attacks on Jehovah's Witnesses, even including to the point of castration. So they're seen as unpatriotic. And one of the things that we're going to find in the next part of, in the next chapter, is these laws are going to go down under the free speech clause. Then we're going to see here is that, an opinion by Justice Wiley Rutledge here, another Jehovah's Witnesses, Prince of Massachusetts. Massachusetts said minors were prohibited from selling magazines, newspapers, periodicals, or other merchandise. So their parents could be charged for letting them do it. So there was a young Jehovah's Witness person that was 9 years old, found that it violated this, and was challenged. The court found in favor of the state. And one of the things that they said here is that whenever you're talking about children, the state has more authority over their welfare. So a child labor law has secular policy. So hence the valid secular policy test. Start getting to a new test. So we're going to walk through a number of tests here. So the compelling state interest test. So in Braunville versus Brown, this is what we kind of know as a blue law. There are blue laws out there. And one of the things that these largely do is different places are shut down on Sunday. So, for instance, in my home state of Indiana, it is a class, I don't know if it still is, I haven't checked the law since I quit being prosecutor. But at the time, I remember, this is something nobody ever charged you with. But it was a Class B misdemeanor in Indiana to sell a car on Sunday. Up until a few years ago, you could not have carry-out liquor in Indiana on a Sunday. You know, in New York, you cannot sell alcohol until noon on Sunday. So these are things that are out there. You know, some places prohibit all alcohol sales on Sunday. Some places require a lot of different things to close. I mean, why car dealers? Some places, though, you know, had where a lot of things were shut down. So as the country has become a little less religious, some of these have started to go away a little bit. You know, what you had here is that Mr. Braunfeld was an Orthodox Jew, and his time that he was taking off was a little bit different. So basically Saturday. So Friday sundown to Saturday sundown. So he wanted to be open 6 days a week, but he was already having to take this off because of his religion. So he said, "Well, let me operate on Sunday." So this was clearly the opinion of a badly divided court. There were a couple of other issues, and it was decided with another case. But Chief Justice Warren adds some interesting language here. But he did, come up with the the belief action dichotomy. So he said, you know what, this could burden some religions. But he said that it is a secular purpose because it gives a weekly respite from all labor of working. So it basically gives people a day off. So it's applied uniformly. But what he says here that veered a little bit. If the purpose of a law is to impede the observance of one or all religions, is to discriminate invidiously between religions, that law is constitutionally invalid, even though that burden may be characterized as only being indirect. But if the state regulates conduct by enacting a general law within that power, the purpose and effect of which is to advance state secular goals, the statute is valid despite its indirect burden on religious observance, unless the state may accomplish its burdens by means which does not impose a burden. Oh boy, what is he doing here? Other means. Least restrictive means. So we're starting to get into that strict scrutiny here. Or some of the things that we associate with strict scrutiny. It's kind of its own test here. Justice Stewart said, I'm going to dissent here. I think it's a cruel choice. He said that it was a violation of the Free Exercise Clause to make him be shut down. Which gets us to Sherbert versus Werner. So this is the Seventh-day Adventist. One of the things is that the Seventh-day Adventists basically observe the Jewish version of the Sabbath. And I think you know that some people take not working on the Sabbath a little bit differently. Some people are like, I don't get to do anything. I have to take the day off. I am prohibited from working this day. Versus some people are kind of like, it's Sunday. We're gonna have some people over, have something to eat, and that's going to be kind of our family day. So some people treat the Sabbath a lot differently. Some people are kind of like, okay, Sabbath? Nope. Had to be not working. So the textile mill, so this was in South Carolina, required her to work on Saturdays, and she was fired when she didn't come to work. So you couldn't get another job in a textile mill in the area in South Carolina to involve Saturday hours. So the state employment office said, you don't get unemployment benefits on the basis that she failed to accept suitable work. So she was offered work at another textile mill, but she said, nope, I can't work on these days. You need to accommodate me. And they're like, to hell with you. So the courts, they said religion was not a valid reason for this. So the state Supreme Court in South Carolina ruled against her. So there's Adele Sherbert. So what she said that this was essentially give up her religious beliefs by coercion. That, she had to choose between being able to follow the dictates of her religious beliefs or making a living. So the Saturday work requirements are not essential to a state policy. What the hell is the state policy to say you have to work on Saturdays and you can't turn down other work that requires you to do so? So choosing Saturday for the Sabbath versus Sunday for the Sabbath is discriminatory and arbitrary. I would just put this out there. If you're picking one over the other, are you not favoring one religion over another? Are you not kind of picking that, the vast majority of people are a part of a religion to some degree that says, this is Sabbath. Some people have a different one. Some people don't do any of them. Some people have none. So for Werner, that's the employment agency in South Carolina, they said, this doesn't equal coercion. There's secular objective in this. She turned down other jobs. And that Bromfield versus Brown controls here. It's only a small economic burden. Now what happens here is that Justice Brennan writes this decision here. So the court comes up with a three-part test, which is somewhat similar to a strict scrutiny test. It's its own little test here, which we know sometimes the Sherbert-Yoder test. The question is, the burden is on the plaintiff, number one. Does this burden his or her free exercise of religion? If the answer is no, the inquiry is over. If not, then the burden shifts over to the state. Was it justified by a compelling state interest? Was it narrowly tailored? And kind of what you're dealing with there, was there no alternative means to achieve the same ends? So a least restrictive means test, if you will. Prong one, she wins. Forces her to choose between her religion and her beliefs. This is privilege or benefit, not the right to receive benefits. So what they said here is, unlike Braunfeld, there is no strong interest to countervail the burden. So the strong interest in Braunfeld was that everybody gets the day off on Sunday. That if you didn't have this, that employers were going to start making people work on Sunday. That everybody gets Sunday off. Now it's a little bit different, that there is not really the benefit as much here to countervail this. Now, on the remaining prongs, the compelling state interest, she wins again. The state presented no evidence as to why they have to enforce this. It essentially, as Justice Brennan is saying, makes her religion a disqualification for unemployment benefits. Now, what this does mean is that, when the burden shifts over to the state, they have to prove both of those two things. Well, you don't really have to go to the second one if you've already failed, or you don't have to go to the third one if you've already failed the second one. So, as you can see there, Justice Brennan is trying to make sense of the previous cases, but coming up with a new test that the court is going to have here. Now, we have a couple concurrences. So there's William O. Douglas, longest-serving justice in the history of the Supreme Court. He mentions, I dissented in Braunfeld. And what he says is that this is basically, what he says here is that this is akin to the Soviet Union. The interference here is as plain as it is in Soviet Russia, where a churchgoer is given second-class citizenship, resulting in harm, though perhaps not in immeasurable damages. So Justice Stewart, he kind of has a little bit more of a snarky reason he's concurring here, and he only concurs in the result. What he says is, you can't square this with the Braunfeld case. The Braunfeld case is saying something completely different, and you're basically, Sarah Palin would say you're trying to put lipstick on a pig. Not that I don't think Justice Stewart would probably be a fan of Sarah Palin. That's another story there. But, what he says is, you need to overrule Braunfeld. Braunfeld was wrongly decided, and you're just trying to cover up that you cited the wrong way on the case. And that they said that the burden in that case was even more egregious than the one in this one. So basically what he's saying here is that I'm not going to sign on to this decision unless you overrule Braunfeld. Now, the dissent here with Justice Harlan, joined by Justice White, he finds that, so he's kind of coming at it a little different way. He's saying, I think you actually did effectively overrule Braunfeld. So he says Justice Stewart is absolutely right, that this is less of a burden than in Braunfeld. But the problem is here, the state's going to grant benefits for some that don't work on Saturdays while denying it to others. So what Justice Harlan here is saying is the state, in other words, must single out for financial assistance those whose behavior is religiously motivated, even though it denies such assistance to others whose identical behavior is not religiously motivated. So he's saying that you're giving special treatment to people that are coming in this particular realm. Now, the Warren Court is going to give way to the Berger Court. So, as we're going to talk about a little bit later in the semester, and I will mention this a lot of times, Richard Nixon, within 3 years, gets 4 appointments on the Supreme Court, including the Chief Justice. That doesn't happen that often, that you get that many appointments within that short a period of time. So, former President Trump got 3 in his one term in office. The last one was kind of a little bit of a surprise. But Nixon got 4. So what's Warren Burger going to do? So the Burger Court ended up, frankly, focusing a lot more on the Establishment Clause than the Free Exercise Clause. And one of the things that you're going to see both here and in the Establishment Clause cases is that Burger wanted to have some type of consistency. So his way of saying that was, I'll assign all the opinions to myself that I possibly can. So how is the Burger Court going to approach this when they get a case? And the answer is somewhat similarly. So in Wisconsin versus Yoder, it involves the old order Amish. So Wisconsin had a public compulsory education act requiring attendance at public-private school up to the age of 16. So the old order Amish, they basically said, we will agree to send our children to public schools up to the age of 8. They were going to homeschool them because they didn't want what they called the worldly influences on them. So basically the Amish, we have the Amish and the Mennonites. Mennonites kind of a lighter version of the Amish, if you will. The Amish, especially the older order Amish, have basically chosen to live apart. They want to live as they did a while ago. They don't want to have a lot of the modern conveniences. So, many of them do not have electricity. If you come from some areas of the country, I know there are a small amount of Amish in southern Indiana, not from the county that I'm from, but from a couple counties over. You would see signs on the road that basically, you see your deer crossing signs, you would see little buggy signs. You would see buggies running along the side of the road. And tragically, sometimes some folks would get run over. Cars would crash into them. Most people tend to be pretty nice to them. And, sometimes they like to invite people into their homes to have dinner. And so there is some interaction. They make great noodles. I'm going to tell you. Never had Amish noodles? You need to try some. But several groups came out to provide legal services to them. A number of other religious groups, groups like the American Jewish Committee, and other people interested in more religious freedom. So basically saying that, the Amish should be able to do this. So there are criminal complaints filed in Wisconsin against several Amish families for removing their children after the 8th grade. So they were found guilty and fined a nominal amount of money, $5. So they were convicted, but the convictions were overturned by the Wisconsin Supreme Court, so Wisconsin appeals. Now, for Wisconsin, what they said, these laws have existed for decades. And what we're interested here is in the child's best interest. They need education to survive in the modern world. So here's some buggies going down the street. So, they don't believe in motor vehicles, some of the older order Amish. So they literally have buggies that are powered by horses. They said it's for the child's best interests. They need it to survive in the modern world. So they said that the controlling precedent here is Prince versus Massachusetts, the Jehovah's Witnesses case that I talked about before. Now the Amish parents here say that the controlling precedent is not Prince, but is actually Sherbert. That the law interferes with the family's free exercise of religion. So that they should have the ability to protect their children from these worldly influences. So the children receive education, just not formally. The education that they're receiving is actually better suited to their lifestyle. So, if you think about what the Amish are doing, how they live out in rural communities. They have very traditional gender roles, of course. The men largely are trained in things like carpentry and in agriculture. Women also work in the agriculture part, but a lot of stuff at home. So it's suited to the lifestyle that they're going to live. So if you ever want to see an interesting movie that involves the Amish, Witness, stars Harrison Ford. So one of the reasons I did want to show you this, other than it's a really good movie that I'm sure you younger people, many of you probably have never seen, but it's actually one of the most accurate descriptions. As I said, somebody that has lived near a number of Amish communities that really do present in an interesting way, in a more accurate way, telling you about some of the practices and beliefs of the Amish, which nice people, um, nice people. Now, what we have here is that you were wondering how the Burger Court's going to go. They kind of go the same way. So the Powell and Rehnquist had not been on the court long enough, so they got sworn in at the very end of '71. If you're a justice, you have to be there for the oral arguments to be able to rule on the case. Now they can order it to be re-argued later, but you have to be there. So what Berger describes is that the Amish society is different. They choose to be apart. They want to live separately. Amish society emphasizes informal learning through doing, a life of goodness rather than a life of intellect, wisdom, rather than technical knowledge, community welfare rather than competition, separation from rather than integration with contemporary worldly society. So what he's saying here is that the Amish have agreed to say we're going to let our kids attend school up until the 8th grade. So we're going to have our kids be able to read and write. But one of the things is, as Chief Justice Berger here is saying, the Amish do not object to elementary education through the first 8 grades as a general proposition because they agree that their children must have the basic skills in the 3 R's in order to read the Bible, to be good farmers and citizens, and to be able to deal with non-Amish people when necessary in the course of daily affairs. So what he's saying here is that the Amish, once they're getting to these areas, so in the Amish belief, higher education tends to develop values that they reject as influences that alienate the man from God. So, a little bit more. Prepare them for their additional obligations. So what he's saying here is, for the court, is that this secondary education would go against their belief system. And the state interest in education is not absolute. It has to be weighed against free exercise. And a lot of this is based in deeply rooted religious belief. Now, more from Berger here. He said that a neutral regulation can be unconstitutional if it unduly burdens free exercise. So that's pretty big there. A neutral regulation unconstitutional if it unduly burdens free exercise of religion. So the state's rationales of self-reliance, self-sufficiency, and intelligent function in society are rejected by the court. What Chief Justice Berger is here, they're getting informal vocational education. They're successful within their own unit. They are choosing to live outside of this. So when Thomas Jefferson emphasized the need for education as a bulwark of a free people against tyranny, there is nothing to indicate that he had in mind compulsory education through any fixed age beyond a basic education. Indeed, the Amish communities singularly parallel and reflect many of the virtues of Jefferson's idea of the sturdy yeoman, who would form the basis of what he considered as the ideal of a democratic society. Even their idiosyncratic separateness exemplifies the diversity which we profess to admire. So, what he's saying here is that they are getting something. However, the evidence adduced by the Amish in this case is persuasively to the effect that an additional 1 or 2 years of formal school for the Amish in place of their well-established program of informal vocational education would do little to serve those interests. It is one thing to say that compulsory education for a year or two beyond the 8th grade may be necessary when the goal is the preparation for a child in a life of modern society that the majority live. But it is quite another if the goal of education is to be used as the preparation for a child to live in a separated agrarian communities that is the keystone of the Amish faith. So, Using Prince versus Massachusetts ignores their parental rights that are involved here. So Berger says there is no harm. Now, there is a concurrence here that we see from Justice White that is joined by Brennan and Stewart. So they would say that this should be more limited in scope. They said that we would rule another way if there was no formal education. So citing there the Pierce versus the Society of Sisters, the case that we had seen before. So they're kind of saying is, okay, we're looking at the difference between going to the 8th grade versus maybe the 10th grade. So I joined the court because of the sincerity of Amish religious policy here is uncontested, because the potentially adverse impact of the state requirement is great, and because the state's interest in education has already been satisfied by the 8 years already spent by the school. So they're saying, when you're talking about the 8th grade, what are you talking about? Like at the age of, 13, 14 or so, depending on if you failed some grades. They said it's more of a specialized situation. So what Justice White is saying is, we really need to limit this to the scope of the Amish. Now, in dissent, Justice Douglas here, dissenting in part, I would say, he also thinks that the court puts too much focus. He thinks that the court puts too much focus on parental rights. And one of the things that he makes a point here, and if an Amish child desires to attend high school and is mature enough to have the desire respected, the state may well be able to override the parents' religiously motivated objections. So he's kind of saying, if some of the Amish folks, if the Amish kids, if they want to go to high school, we should not let the parents override that. That's where Douglas is coming. So the last slide here, the subsequent Berger Court cases as we're getting in there. In Thomas versus the Board of Review of the Indiana Employment Security Division, Jehovah's Witness was transferred to steel mill mid tanks. Quit and was filed for unemployment benefits. Court ruled in his favor based on Sherbert. Bob Jones University, notoriously racist university in Greenville, South Carolina, school had a ban on interracial dating, justified it by religion. IRS took away the tax exemption. That's where you're really kind of getting into stuff. Tax exemption. So the court said ending racism was a compelling state interest, and this couldn't be achieved by other means. So they said you could still practice your religion, you just don't get a tax credit for it. We're just not gonna put you in a better position. So next time what we will do, we have a little bit less material than we kind of do here because I had a little more of an introduction than I thought I was going to, so this next one should be a little bit shorter. We're going to see that the court's going to adopt a new test in the Smith case. Then Congress is going to respond with RFRA, as we're going to know it. The court responds to that in City of Bernie versus Flores, and then we start getting that the politics of the issue change. So it becomes more that certain religious groups are trying to resist societal changes, as we're going to see. So we're going to see 3 new cases from the Roberts Court. So until then, I hope everybody is safe out there and is well. So until then, I will see everybody next time.